Today we'll be discussing how some of the world's most powerful law firms have run into a greater power. John, what are we talking about today?
We're talking about the executive orders that President Trump unleashed against law firms soon after he took office. We're talking today to Jeffrey Toobin. He's an author and journalist, staff writer for The New Yorker, author of many books, and one of the leading voices translating difficult legal issues for popular audiences.
We thought long and hard about who to talk to about this, and some of the people in the center of the storm just can't come out.
He's an independent voice. He explains these kind of issues on TV and in print. I think he'll offer some great perspective.
All right. So, John, should we bring on our guest today?
Yes, let's do it. Jeff, welcome to the podcast.
Hi, Professor.
Hey, what about me, Jeff? I don't get a hello?
What about you? No. I mean, when you're a professor, you get a hello. But until then, forget
All right.
it.
Jeff, we're talking today about something that's probably caused a lot of stress and attention, at least in our profession, these executive orders against law firms. You've covered kind of presidential power grabs writ large over a long period of time. Is there anything that you see here? Is this something totally out of line, something special, or is this just a new form of it?
That's a really interesting question and a really important one for this subject because, in our world, in the legal world, there has been a tremendous amount of discussion, as there should be, about which law firms have caved and which law firms have fought and which law firms volunteered to cave. And as far as I'm concerned, not enough about the sheer outrageousness of the president's demands on these law firms. The term unprecedented is overused in our world and in the legal world, but what the president has done to these law firms is literally without precedent. The idea that dissatisfaction with the political or personnel decisions of law firms could result in formal legal sanctions against them has never happened before in the history of American law. And as the four judges who have reviewed these cases so far have concluded, it's also illegal what the president has done. But, I have spent a good deal of time belaboring the law firms that have capitulated, and I think they deserve belaboring. But I don't think we'd spend enough time belaboring the actions of the president that created this whole controversy.
I know we're going to get into why and how some of the firms caved and some that stood up, but maybe, and John, you've actually written on this topic as well. Maybe should we set the stage a bit for those who maybe are stuck in this ever fast-paced news flow and forgot what these orders are?
Sure. Maybe, Jeff, we could just ask you a few questions about it to start. So there were, in my understanding, about 14 firms that were either targeted or threatened to be targeted. And I think about 9 of them settled and avoided getting actually an executive order issued against them, but several of them litigated. So just bring us up to speed on where things stand right now with the ones that we're litigating.
The 4 firms that have litigated are, and correct me if I'm wrong, Perkins, Coie, Jenner and Block, the Sussman firm, and Wilmer Hale. And all 4 have won preliminary injunctions in the district court. Interestingly, for a long time, by current standards, the Trump administration did not appeal any of those. They didn't run out the clock. I think they still have the legal right to appeal, but they eventually did appeal the preliminary injunction in the Perkins Coie case, which will be litigated in the weeks and months ahead. But the important point that all 4 district court judges concluded is that the president's sanctions on these law firms were unconstitutional. I think the president deserves a kind of perverse credit because it's rare that a executive order violates so many provisions of the Bill of Rights. He missed the Third Amendment about the quartering of troops in people's houses, but I mean, arguably, and in fact, the president's actions, violated the First, Fifth, and Sixth Amendments, which is pretty rare for a single executive action to violate three of the amendments in the Bill of Rights. Oh, and the 14th too. It's not the Bill of Rights, but it is an amendment.
Yeah. So tell us, how were these law firms targeted?
Well, it varies, by law firm, but I think what they all have in common is that none of them were accused of violating the law, or any law. They were accused of essentially political crimes. Perkins Coie has been long well known as a firm that frequently represents Democrats, represented Hillary Clinton's campaign, represented the Obama campaign. That was their crime.
Jeff, it's the craziest part about that one was that the lawyer in question had left the firm, right?
That's absolutely, and that's true of the Paul Weiss offense as well. The Paul Weiss lawyer who offended the president left the firm to go work in the New York DA's office on the case that became the criminal case against Donald Trump, although not exactly that case. In fact, his version of how the prosecution should go was rejected by Alvin Bragg, and they went with a different theory. The other sort of general complaint about these firms is that their diversity efforts were somehow inappropriate. But I mean, the real accusation against these firms, the ones that there was formal action against, not those that preemptively surrendered, because we don't even know what the allegation against them would be, is essentially political crimes, and that's one of the reasons why the four judges found their actions found the White House action unconstitutional.
Do you see some echoes of Nixon's enemies list here?
Well, echoes, but for all that, I just wrote a book about the presidential pardons, with a focus on, for Gerald Ford's pardon of Richard Nixon. But I think the important thing to remember about the enemies list is the list existed, but there were no formal sanctions attached to it. I mean, it was, they talked about, unleashing the IRS on people. They talked about various things, but they didn't do it. I mean, what makes this worse than the enemies list is they actually used the power of government to sanction these law firms in ways that were really very, very crippling. I mean, just to remind people, disqualification of certain lawyers from getting security clearances, but more importantly, barring lawyers from federal buildings.
Would that include even courthouses, do you think?
Well, that would be an interesting constitutional question, whether the executive branch could bar lawyers from Article III courts.
Well, maybe it was actually a gift, some level of immunity. You can't stand trial for any criminal cases because you're not allowed in the courtroom.
Yeah, but I mean, it's my sense that lawyers like to be hired to.
Okay, I take back my joke. I shouldn't be making light. This was very serious.
So yeah, they can't be arguably they couldn't be defendants, but they couldn't do their job, and I think that's the most serious and in many respects just the craziest part of these sanctions, barring them from federal buildings, and putting aside the Article III issue of whether you could bar them from courts. A lot of what lawyers do, especially in Washington, is they go negotiate with the federal government over, on behalf of their clients, over contracts or over the end of contracts. Most The reason law firms have offices in Washington is by and large to deal with the government. And if you can't go to the government, it makes it very hard for these lawyers to make a living, which is obviously the point of these sanctions.
John, in some of your conversations with law firms and partners, what about the repercussions for their clients? I know that this was a big fear for the law firms.
Yeah, so in addition to the security clearance revocations and the bans on federal building access, the executive orders also revoked any contracts between the law firms and the federal government. But more importantly, they were going to revoke contracts or challenge contracts between the law firm's clients and the federal government. So if you're like Boeing, the airplane manufacturer, and you hire Perkins Coie to represent you, you could lose your government contracts as a result of your work with Perkins Coie.
I'm glad you mentioned that, John, because I mean, in many respects, that's the most important sanction that was in. It wasn't. I don't think it was in all of the executive orders. It was in some of them, but you know, law firms, to state the obvious, exist to service clients. And if your clients can't deal with the federal government in any way, and a corporation like Boeing, lives and dies by government contracts, that is an existential threat to the existence of these law firms.
I mean, there's also just more generally the government's potential unwillingness to deal with these law firms and their clients, right? Even if a law firm lawyer is able to gain access to, say, the FTC's building, and even if the government isn't formally revoking contracts from a company, the commissioners of the FTC could just say, we don't like you, or we don't like your lawyers, and therefore we're not approving your merger.
And in my conversations with the lawyers at these firms, that is the point that they emphasize about what a threat these orders were, is that if we are perceived as at war with the federal government, if we literally go to war, if we litigate against the federal government, how can we continue to represent our other clients in our interactions with the government? That even if there is not the formal bar on our clients dealing with the government, but just the existence of this conflict makes us either unhirable, which is a problem for new clients, or unable to do a good job when it's quite clear that from the president on down, the federal government hates us. That would redound against our clients and
the duty that lawyers have to their clients.
Correct.
Is that what you were hearing, Jeff, when you spoke to a lot of these people who aren't going on the record? Is it fear for their clients, or that their clients will exodus? What were you hearing?
It's all about the clients, and I don't mean that as the fear I hear is all about the clients, and I don't mean that in any sense that they're not fearful of themselves, but they are fearful of themselves because of the threat to the clients. That why would anyone hire us if we're at war with the federal government? How can we represent clients if we are perceived that way, both existing clients and future clients? So that is the hard, much more than the barring from federal buildings, much more than the individual lawyers getting security clearances. The idea that we're at war with the federal government makes it impossible for us to do our job for our clients, and thus makes it hard for us to get clients. That's the heart, at least in my experience. Is that your sense of it, John?
That is, the whole point of hiring a lawyer is to get better treatment under the law. And if hiring a particular lawyer is going to get you worse treatment, you'll just hire a different lawyer. And I think we can get into this in a moment, but I think one of the most damaging aspects of these executive orders is they didn't apply to the legal industry uniformly. There are lots of industries where there are regulations that apply to every player in an industry, food and drug regulation, airline safety regulation. These executive orders singled out individual law firms, which meant that if one law firm was disadvantaged, clients could just go to another law firm. And that's why it was so uniquely catastrophic for the firms that were targeted.
And I mean, I don't know if we're going to get to this separately, but this presents a problem even for the firms that fought back. Because, one of the big issues that I have been interested in trying to find out, and I can't say that I've, been wholly successful, is what has this meant for the four that fought back?
I would love to know that.
Well, like some I think is some of the implications I think are clear. For example, it makes them very attractive to law students. I think law students like the fact that these four firms have fought back, and they have seen an increase in the number of people who want to work there. I think the associates at these firms feel highly motivated by the fact that these firms are standing up for their rights. But as a senior partner at one of these firms said to me, and the other issue is, are they losing their existing clients? And as far as I can tell, I mean, these law firms are very private. As far as I can tell, they are not losing a lot of clients. But the real concern is this, is if you are at sanctioned law firm A, and sanctioned law firm A has fought and won against the federal government, in getting new clients, how do you say, well, hire me to negotiate with the federal government while I am suing the federal government? That's a very hard argument to make, even if you are a very good lawyer and otherwise might be hired by these clients. That it's not so much they are losing clients, but they are that it hurts their future business aspects. As one of them said to me, I'm worried, why hire me at this firm that's fighting back when you can hire, pick a law firm that's simply not involved, that hasn't capitulated or hasn't fought back. It's just not involved. Cravath, Swaine and Moore, Cleary Gottlieb. Lots of these firms are just not involved. Why not hire them instead of one of the four of us, so you don't have to deal with this whole potential problem? And that's a very real concern, and I don't know what they can do about it except capitulate, and they don't want to do that for understandable reasons.
I've talked to a couple of general counsels who say, we're so impressed with these law firms that are standing up that we're going to steer business towards them. But I can tell you the kind of business they're not steering towards these law firms is any kind of business that depends on the approval of the federal government. It's for private litigation, for private contracting. It doesn't require federal approvals and so on.
Well, and here is one aspect of the legal profession story, which I think has been exacerbated by this whole controversy, which is the distinction between a corporate practice and a litigation practice. And I think in these firms, you are seeing a real split between litigators and corporate lawyers, that I mean, there are always differences, but I think it's a really big difference because the corporate lawyers, the ones who, as you say, John, want to have to negotiate approval for mergers or whatever with the federal government, they are the ones who we don't want this controversy, let's settle it. And the litigators, who are fighters, and that's what they do. And sometimes they fight the government, sometimes they're on the same side as the government, but the existence of these sanctions and the existence of the fight over the sanctions doesn't hurt the litigators as much as it hurts the corporate lawyers. And I think that split is a very interesting implication of what's happened as a result of what the Trump administration has done.
For sure. If we look at the firms that have settled and the firms that have litigated, all of the firms that have litigated are either exclusively or overwhelmingly litigation focused. And all the firms that settled have large corporate practices in addition to their litigation practices. And if we look at the firms that have represented some of the firms that have been targeted for these executive orders, Williams and Connolly, Quinn Emanuel, those too are litigation-only firms. So I think that's really crucial. One other reason why corporate lawyers are uniquely sensitive, or why firms with corporate lawyers are uniquely sensitive, is that my understanding from having talked to a lot of lawyers is that corporate lawyers can move firms more easily than litigators. Their matters turn over more frequently, and so it's easier to change firms without leaving a lot of value behind and disrupting the experience of your clients. So that makes corporate firms more fragile.
That's very interesting. I hadn't thought of the turnover issue, but that has to be true. I mean, another word for corporate lawyers sometimes is deal lawyers, and deals. You hire a lawyer. A company hires a lawyer when they're doing a deal. A deal is not going to take a year or 2 years. A major piece of litigation very well may take a year or 2 years or 3 years, and it is much harder to bring a matter like that to a new law firm than it is to bring a deal across the street.
Jeff, I wonder, given the breadth of your coverage, have you seen, like, this really strikes me, the Paramount settlement, the way that here we have a potential M&A deal. Paramount is trying to, am I right? It's Paramount, right? That's selling.
The parent
CBS.
company of CBS.
And they need government approval here. They need the government to say this doesn't violate some type of trade restriction. And as a result, maybe not, maybe it's not, maybe it's happenstance, we see this payment going to Donald Trump for his litigation against 60 Minutes. I mean, it just gives teeth to the idea that, look, if you piss me off, you might get scrutiny. That $2 billion merger might not go through.
Your statement is full of hedging words like might, and it's a straight up bribe. I mean, that's all it was. The $16 million for a completely unjustified lawsuit was a straight up bribe, so that the FCC approves the deal of the parent company of CBS. And it's just, the four words that I have used about the Trump administration, both this term, especially this term, but last term also, is shocking but not surprising. The idea that the federal government, not the federal government, Trump's lawyers held up a merger for a payment of a completely frivolous law settlement is shocking, but I suppose not surprising, given the way this administration has acted. But I mean, it's not like, I mean, I've also done a lot of reporting on libel and defamation, and but you don't have to be a big expert to know that the claim that President Trump and his lawyers made about the 60 Minutes broadcast at issue was completely frivolous.
There was an edit, Kamala Harris interview. There was an edit where part of it was cut or played in an earlier teaser, but not during the actual 60 Minutes broadcast.
Right. There is not a chance in the world that a judge would let that even go to a jury, much less have a jury resolve it. But Shari Redstone, who is the controlling shareholder of the parent company, she'd lose a lot of money if this deal doesn't go through. So they settled, but it had absolutely nothing to do with the merits of the case, which were non-existent.
In the case of Paramount, you can understand why they would pay what you're, I think, justly calling a bribe. In the case of the law firm, some people might say, well, there's not that much at stake. Many of these firms are highly profitable. The partners earn on average millions of dollars a year. Why not just accept a pay cut of $200,000 or $500,000 a year in order to stand up for principle? What do you think about that, Jeff?
I think that's a good argument. And
Good. I know you guys are going to fight this one out.
you said millions of dollars. The top partners at Paul Weiss, and it's true at some of these other law firms, make $25 million a year. I don't know if you're familiar with that. I know Yale law professors are paid very well, but they are not paid $25 million a year. And in fact, we now are in an era where the lawyers make more money than the clients, which to me is just astonishing, and is a real reversal. So, the dollars at issue for the top partners are simply astonishing. Before I started reporting in this area, I had no idea that lawyers at, say, Paul Weiss made that much money. The really distasteful aspect of the settlements here, and starting with Paul Weiss, is that it looks like, and in many respects is, a sacrifice of principle so that people can keep making these extravagant salaries. This is something that President Obama, who among other things is a lawyer himself, he said these law firms are failing to stand on principle so that they can have a better house in the Hamptons. And that's a pretty ugly criticism, but as far as I can tell, it's accurate.
John, you mentioned this kind of prisoner's dilemma issue, that it was because it was going after only a few of the firms. Do you think that kind of made the pressure on these firms from their clients more of an issue, rather than the ability to, as Jeff's saying, tighten the belt a little?
Yeah, when Brad Karp wrote the memo to the firm announcing the settlement with the Trump administration, he said that the threat to the firm was existential. It wasn't just that the top lawyers were going to make $500,000 or even $1 million less every year. The threat to the firm was existential. So I've actually written a little bit, we've mentioned this already, I've written a little bit about this, particularly in an op-ed in the Wall Street Journal. I think that Karp was right about that. The reason is that law firms, unlike ordinary businesses, are vulnerable to a kind of spiraling cycle of decline that resembles a run on the bank. Law firms are owned by their partners. And so what happens is, if one partner leaves and takes clients with him, and the firm's
probably going to be one of those $20 million partners that Jeff was talking about.
It absolutely is going to be one of those $25 million, because it's only the corporate lawyers that are making that amount of money. Scott Barchet is the most famous example at Paul Weiss, who moved from Cravath and who I conjecture would move again if his clients were being hurt. So suppose he leaves and takes a bunch of business with him, but the firm is stuck with the same office leases and a lot of the same associates and secretarial staff. Well, the firm's going to be less profitable as a result. And because the firm is owned by its partners and the remaining partners are paid in shares of the profits, their compensation is going to go down. So then some of them are going to move and they're going to damage the firm further still. And then some more of them are going to move and some more until you end up in a spiraling cycle that resembles a run on a bank. And eventually people will leave even when their clients have not been harmed. And they'll leave not because their clients were harmed by the executive order, but because their profits were harmed by the departure of so many other partners before them. And so there's a way in which even a relatively modest decline in compensation can turn into a catastrophic blow to the firm that could destroy the entire firm. And if you're somebody like, say, Brad Karp, the chair of Paul Weiss, or if you're the chair of one of these other firms, you're looking not only at all of your partners having to change jobs, you're also looking at loss of jobs for your associates, for your staff, for your cleaning personnel. Right? All those people will be out of work if the firm collapses. I think that's a big risk to take.
I think you have very accurately presented the worst case scenario that Brad Karp was worried about. That's what he meant in that memo. by the existential threat, this run on the bank. And, my response, and I think President Obama's response, I'm paraphrasing, is too fucking bad. Is like, that's sometimes you have to take a stand that has financial risks. And it's true that the risk you described was a risk. It is not a guarantee. If Paul Weiss is as great a law firm as Brad Karp always says it is, the departure of one or two even very successful lawyers like Scott Barchet should not create an existential problem for the firm. And I think it's important to point out that yes, that the run on the bank risk is real, but so is the risk of capitulating. That capitulation has risks too, to your firm, to the legal profession as a whole, and I think you have to weigh that against what is a real risk that you describe, but a speculative risk. And I think the use of that word existential is an important one, but is not and should not have been dispositive to how Paul Weiss resolved this.
So the risks on the side of settling include, for instance, that law students won't join your firm any longer, and that a handful of clients might leave in disgust. Whereas the risk on the side of not settling is the destruction of the whole firm, potentially. I agree with you. Nobody knows exactly how serious the risk of destruction of the whole firm is, but that, in a sense, is kind of the point. You don't know. You're taking a huge gamble. And you'd mentioned earlier that these executive orders are unprecedented. I think that's precisely what makes the risk so hard to predict.
I think you're right that it is hard to predict. But there's a word to describe the people who work in these law firms. It's lawyers. They're supposed to predict like what things will happen and play a role in making outcomes happen that they want and that their clients want. So I think you're giving the law firm a bit of a pass. You're giving Paul Weiss a bit of a pass by saying, well, there was this existential risk, so they had to capitulate. No, they didn't. That was a risk, but there were ways of mitigating that risk. And I think, given the full context of this story, they were obliged to take that risk.
Jeff, what do you think about what the settlements demanded? Because from conversations I've had with partners at firms that did capitulate, was that to some degree it was just the capitulation, kind of a symbolic bending of the knee and not much more.
This is a great question and very much an outstanding issue in all of this. Just to refresh people's memory or tell people what they don't know, the capitulating firms agreed to provide millions of dollars in pro bono services to causes approved by the Trump administration in return for not having the executive order. Paul Weiss said $40 million, Skadden and Latham and all those agreed to even more. And the areas described were fighting anti-Semitism, veterans rights, and these firms have said, well, we do that anyway, so there is essentially no penalty that we are facing by our settlement. I think the jury is out on that issue. I from everything I know of how Donald Trump works and the Trump administration works, is that when you capitulate to them, they don't just say, "Oh, well, thank you. Now let's just proceed along." No, they do what bullies do. If you capitulate at one point, you'll capitulate again. And this is not a hypothetical. Trump has said at public events, and I wrote about this in a piece in the Times, people upset about coal mines being able to open again. They want these voluntary firms to help them there. I'm blanking on some of the other stuff, but political causes of the Trump administration that they want that they want these firms help on.
I think he said he wanted the firms help negotiating trade deals.
Trade deals, right? And as I understand it, so far there have been either very few or no demands made on the law firms pursuant to these agreements for pro bono services. But I don't think that's a guarantee at all that the Trump administration will not demand pro bono services in the future, and that could create a lot of difficulty for these firms, especially if they are causes that many of the lawyers don't believe in.
And these are top law firms, top lawyers. One thing lawyers love are very clear contractual language. Were there agreements? Were there written agreements? Or what do we have here?
Paul Weiss, there is a written agreement. Some of the other firms, there is not, as I understand it. And as they say, an oral contract is not worth the paper it's written on. I can assure you that if you ask Donald Trump the agreement,
he'd have a different understanding.
You ask Donald Trump what the agreement stood for, and if you ask the head of Skadden what the agreement stands for, you would not get an identical answer from both.
Was the agreement with Paul Weiss published?
Not in public, but it has been attached to documents that have been made public. And it does refer to these specific subject areas of pro bono services. But they are defined in broad enough ways that, lawyers can read words in different ways if they want to.
Right.
And it doesn't say the firm is obligated to provide those services to the government or to Donald Trump. Right? They can be provided to other clients, correct?
Very much so, but they have to be clients approved by Donald Trump. That's quite clear, that there is mutual agreement on what I don't have it in front of me, but I think it's the firms and Trump have to agree on who the clients are and what the representation is for it to be in satisfaction of the $40 million worth of services.
So Skadden can't just say, those asylum cases, we're counting those towards your bottom line.
Skadden, I believe, is in the unwritten category.
Right.
So who knows what that would be like.
I mean, there's something very Trumpian about kind of leaving the bargain uncertain so that he can change it after the fact.
Well, this is not, if the one thing we know about Donald Trump as a businessman is he stiffs contractors. And these law firms are essentially now contractors. So the idea that these law firms can say, well, we know our obligations because we have an agreement with Donald Trump, is like, where you been, pal?
So suppose that the Trump administration actually demands that the law firms represent the coal industry, or that they represent the government in litigation against individuals that these firms think are really odious. My impression is that might be the point at which even the settling firms will say, no, we're not doing this. What do you think, Jeff?
I agree. And at that point, my assumption is Trump would just impose the sanction he threatened in the first place, which would force the law firms to go to court, which is what they should have done in the first place. And so, I mean, that to me is exactly why they should have gone to court in the first place.
What if one of these firms were to litigate and lose so that the executive order stuck? Then do you think my collapse risk would be really serious?
Well, let me spin that out in my head. I'm sorry to have to think, because you don't like to have people thinking on a podcast.
Well, it's also, by the way,
Well, so you're saying the firms go to court, lose, and the executive order stands. Well, then I think, well, let's see. I think then you would be in a situation where the firms are conceding, have to follow the executive order, which means they are not in conflict with the administration anymore. So you wouldn't have the need for the people to flee.
if the executive order stands, then they don't have security clearances, they don't have access to the government, their clients lose their federal contracts, right? That's what happens if the order stands. And if you're a deal lawyer at Paul Weiss, you can't live under those conditions.
That's true. That is certainly a problem. When I was in law school, one of the things the professors always said is, like, don't fight the hypo. Don't argue with the premise of the Socratic question you are asking. But because I'm long out of law school, I am going to fight the hypo, which is, I don't believe any court in America would ever sustain these executive orders. I think the fact that these 4 judges who are appointed by different presidents have all ruled exactly the same way, the risk of losing the case, obviously, you never can say zero, but I think is so small that I think the hypothetical that you are spinning out is just simply not realistic enough to worry about.
If the question is, should the firms have settled or not, then the fact that they would almost certainly win is relevant. If the question is, are these executive orders justified and would they do damage to the law firms, then if we really do keep the hypothetical and imagine that the government might win, then you would agree, right, that the consequences to a law firm would be catastrophic of one of these executive orders sticking.
Yes, that would be a terrible thing for a law firm, and it would present, I don't know if existential, if these firms would no longer exist, but it would be devastating to the business and the law practice if these orders stuck.
I think we don't even have to get to the what if they win. I think if it's sort of like the trade war, if the government just went after one country, that country would have a very, very little chance. But if they go after all of them, then it's maybe less effective. I'm just imagining if they singled out one of the corporate firms, and I don't want to name any because I don't want to put any paint on them. But let's say they went after a leading corporate firm and lost. Well, I could certainly imagine some of the more risk-averse repeat players still leaving that firm because they know that it's under the ire of the government. And that alone might be enough to, if not take it down to a lower tier, maybe even, threatens its existence.
I mean, all of which is bad. I mean, I don't want to pretend that Paul Weiss and company had easy decisions to make here. And that's why, when we began this conversation, I think it's important to assign the principal blame not to the law firms, but to the Trump administration for starting this cycle, if you want to call it that, in the first place. But this is, and again, I don't mean to be facetious here, but lawyers have to make difficult decisions all the time. And this is one that is not just for their clients, but for themselves. So the question is how to respond to this outrageous behavior. And again, I don't pretend that was easy on the part of Paul Weiss or anyone else. But I think, the balance of equities, both on a moral level and as a business, I think in the long run, it was the right decision to fight.
Find some more bravery.
Barack Obama thinks so, for what it's worth.
Well, we've got Jeffrey Toobin and Barack Obama on one side. John, I think you better hang up your hat.
It's a fight. Let's maybe just shift a little bit and think about the costs of these executive orders for the whole industry. So suppose you're a firm that hasn't been targeted, and never settled, never litigated, but you know now that there's a risk that if you do something that upsets the government, you hire the wrong guy, you start the wrong lawsuit, you represent the wrong clients, either pro bono or for a fee. Does that change the calculus about how you do your business?
You bet. You bet. And I think it's already started, from what I understand. That, when in the first Trump administration, if you recall, in the first days after Trump was inaugurated in 2017, there were all the issues related to the Muslim ban. This idea that Trump was going to ban Muslims from coming to the United States. And these big law firms, en masse, unleashed their associates to represent people at airports, and there was great pride in the legal establishment, and the fact that they're standing up for the powerless. I think in this round, the number of law firms willing to stand up, especially in a pro bono context, is a lot smaller, for just the reason you described. That you don't want to raise your head and get on the enemies list. And that applies to both pro bono clients and probably less so to paying clients, because lawyers like paying clients and they're willing to take some risk for paying clients that they are not for pro bono. But it's just a fact that these lawyers are much less willing to fight than they were the first time around.
It just has to have changed the calculus. It just has to have. I'm curious, John, have you had conversations about this?
For sure. I think there are firms out there that keep doing certain things, often progressive causes, but what they won't do is things that they know are really important to the president.
Let me, raise a related point to that, which is there have been amicus briefs filed by law firms in these cases where the other lawyers have pointed out the threat to the legal profession and how outrageous these orders are. These amicus briefs have not been signed by lots of big firms who certainly know that these orders are unconstitutional and terrible for the profession. They're doing it because they're afraid to become a target. If you look at those amicus briefs, they are, for the most part, smaller, more sort of politically engaged firms. Not 100%, but the big firms that are neither targeted, neither capitulating nor fighting,
they're keeping their mouths.
Their names are not part of these briefs because they didn't want to make themselves a target.
The nail that sticks up gets hammered down.
Exactly.
What are you seeing? Is there anyone defending these orders or this type of argument that law firms had too much power, et cetera?
I think these law firms are defending themselves, and they are saying, as John was saying, that what we're really doing is protecting the jobs of the cleaning women in our offices. That's really what this is all about, which to me is utter bullshit. But this idea that we're responsible for all these associates, and that it's not about the $25 million a year lawyer, it's about the cleaning women that's the defense, that we are obligated to our clients and to our employees, and this is the way to respond.
I'm asking a different question, which is, have you heard any argument with any legal background or any credible, and I hate to throw it under the bus before I put it out, but I guess, have you heard any argument that these firms needed to be taken down a peg?
I see that argument. And I mean, I guess that the fact that I haven't um, means I live in a horrible bubble and I should get out more. But I think a pretty good sign that such an argument is meritless is what the judges decided in these cases. It's not just that, I think the argument is bullshit. It's like the judges seem to think so as well. But you're right. And I think you're right that this is an issue that, people need to think about is, why did the president decide that taking on a fight against these law firms was a good idea and at least politically valuable, if not legally justifiable? That's a point, worth thinking about, but I don't think it changes my view of the merits.
And I guess if you just look strategically, who ended up with more power at the end of this? To me, it seems unequivocally the president. So if there's a winner, it's the executive.
100%. 100%. I mean, if you had, I think I have a decent, imagination. If you had said to me, on January 19th, 2025, right before the president took office, and said, is there anything the president can do unilaterally that could potentially drive Paul Weiss out of business? I'd say, I don't know. I don't think so. And I mean, what do you think, John? I mean, did this occur to you that this was a possibility? I mean, maybe it's a failure of imagination on my part, but it simply didn't occur to me that this might be done.
It never would have occurred to me. This is as arbitrary an exercise of executive power as one can imagine. It's just a lawless, explicit targeting of political opponents. I just don't know how else to make sense of it. I mean, this is part of why we were asking you, Jeff, if you could imagine, if we could steelman this somehow and try to imagine what the argument in favor of it might be. It's just hard for me to see.
Steelman? What's steelman?
Well, it's the opposite of a straw man. So
cool. I never heard that word before.
It's a professorial thing. Maybe you should.
I see. Okay. No, I get it. No, okay. I was just steelman. I don't know. There's a professional golfer named Kevin Steelman, and I thought you might be referring to him, but it did seem out of context. So,
Jeff, a topic that you've covered, I wonder if you think of this as related. The Supreme Court's decision on presidential immunity. I can't help but just see how, even with losses in the courts on these executive orders, they still feel like such a win to me for the president. And I wonder if you see that get out of jail free card of sorts that John Roberts' decision gave as empowering this.
Certainly. I mean, let's just talk about John Roberts in particular. I mean, the formative experience of John Roberts' professional life was out of law school and out of his clerkship serving in the Reagan White House, where he was very concerned, as was the broader administration, that the post-Watergate reforms had weakened the presidency. And he is someone who has devoted much of his career to advocating and now ruling in favor of executive power over, the legislative power or judicial power. I mean, that's nothing new. And Trump v. United States is, a really expansive elaboration of views that he has had for a long time. And part of this, So that I think is Roberts in particular. There's also the question of how cynical you want to be about the Supreme Court in general, which is, is this a principled fight over, executive power versus constraints on executive power in various forms, or is this a bunch of Republicans on the Supreme Court just trying to help Trump and screw Democrats?
I hope that's not the case.
Oh, really? Oh, isn't that adorable that you hope that? That
Jeff, I am loving this conversation.
okay.
I'm really loving it.
But plausible arguments can be made for both of those scenarios, and they are not mutually exclusive either.
So, Jeff, maybe let's ask, what do you think the legal industry specifically might do to guard against the possibility of more executive orders in the future? We know that there might be more coming. We've already talked about how the industry is acting anticipation that there might be more orders coming. What could be done?
That's a great question, and I'm in my business. I think of I do problems, I don't do solutions.
Okay.
So I don't I don't know, but I mean just to be straightforward about it, I think you have to fight them.
More backbone.
Joel, you mentioned this earlier. I think there is strength in numbers, and I think in many respects one of the most depressing aspects of this was the preemptive capitulation of the firms that weren't even sanctioned in the first place. I mean, in a way, I feel sorry for Paul Weiss, which has become sort of the official symbol of capitulation. I mean, at least Paul Weiss was threatened with an actual sanction that had, all these law firms marching in there to surrender preemptively, the Scadams, the Latham and Watkins, the A&O Shermans. I mean, that to me, in many respects, is the worst. And I think what I mentioned earlier, the failure of so many big firms even to sign an amicus brief, opposing these obviously unconstitutional orders, doesn't augur well for the collective action that I think should be necessary. But I guess I don't have a better answer than you just have to fight these things. Do you have a better answer, John?
Well, the American Bar Association has brought a lawsuit seeking to enjoin further executive orders. And I think the point of that is really to address this collective action problem by having an industry-level organization do it.
I guess I'm aware of that case. Who represents the ABA in that case?
I think Sussman Godfrey.
Well, I mean, I guess that's a good idea. I think they have a very good case once the orders are issued. I think a preemptive case is going to be a tougher sell, but who knows?
A big question, I feel like these executive orders are a microcosm for the Trump administration generally. The Trump administration is doing so many things where you just look at them and think, gosh, I never even thought that would be a possibility. And I think if there's a Democratic administration of the future or a Republican administration that's less committed to this manner of governing, a good question we could ask is, what legislation would you put in place to stop this kind of thing from happening again? My own answer is, gosh, I don't really even know. What do you do? Pass a law that says the president can't issue crazy executive orders against law firms for stuff their former partners did after leaving the firm? What does that even look like?
Well, I do. Crazy is a good legal term of art too that I like. That I think would be good in a statute. No, I think it's very hard. One of the things that the Trump, the future Trump administration did during its 4 years in the wilderness was think through a lot of these ideas. Some of it came through in Project 2025, the book that was written. But
oh God, was this in there?
I don't think this was in there, but some of this stuff was in there, and Did you think that they were going to use the issue of anti-Semitism to try to take $4 billion in scientific research away from Harvard University? I didn't. But again, this is where the process, in many respects, is more important than the merits. I mean, I think there are obvious similarities between what's going on at these universities and what's going on with these law firms. Is that if Harvard is fighting back and trying to get the pledged or contracted for scientific money that they were promised, and so far they've done well in the courts, but you can't go to court and say, promise us money in the future, because that's what Harvard needs. I mean, these are recurring contracts and so one hypothesis that I have heard is that even if Harvard wins these cases, Harvard is screwed anyway, because the Trump administration is simply not going to make new grants in the future to Harvard, and if cancer isn't cured, too bad. When you, the Trump administration, are willing to violate norms to such a degree that you come up with things that even smart Yale law professors didn't even occur to them, I don't know how you would do statute writing in advance to prevent that. And again, the legal fights over them, even if it is illegal. I mean, some of this stuff that the Trump administration has done, like the university stuff, like the law firm stuff, has been found to be illegal. But these institutions are still in deep trouble anyway. So that really makes the legal remedy much more problematic, because even if you win, you lose.
Something I think about a lot is that rules are always incomplete. A rule that you write down in a contract, in a statute, in a constitution, it can never specify all the details of how you want someone else to behave. And as a consequence, you have to rely on some element of good faith, some internal willingness to comply in order for the thing to actually work. And I think that for 250 years of American democracy, we had good leaders who kind of internalized the norms of democracy. And even if the Constitution couldn't place tight limits around everything they did, they sort of understood and acted consistent with the spirit of the thing. And I think what we're witnessing now is an administration that will press the letter of the law to the greatest extent possible and ignore the spirit. And when somebody does that, it's very, very challenging to use the law to constrain them.
That statement you made just reminds me of a scene from the White House tapes in the Nixon era that reminded that it came up in my book about pardons, where in the immediate aftermath of Watergate, Howard Hunt and G. Gordon Liddy, who were sort of the architects of the Watergate break-in, they go to John Dean, the White House counsel, and they say, "We want pardons. We don't want to have to face criminal liability." And Nixon and John Dean talk about this, and they basically reach the conclusion that, of course, I have the power to pardon Nixon and Liddy, but it would look so bad. It would look terrible. It would be a violation of the norms of how pardons are used. And they don't do it. And none of the Watergate people are pardoned by Nixon, even though they talk about it. This is precisely the norm that Trump blew through, not just with the January 6th pardons, but pardoning all the people that Robert Mueller prosecuted. I mean, he is completely unconstrained by the norms that even Richard Nixon, who was not exactly a paragon of morality, felt constrained by. And that's a difference between the world we live in now and the world that for the previous 250 years.
Jeff, I'm curious, is this a new tool that we're likely to see used again by other administrations. I'm imagining a Democratic administration where they're facing opposition and want to flex their power.
I do think that if there is a Democratic administration in 2029, then that you will see a much more aggressive use of executive orders. I think the Democratic base will demand nothing less. I do think now. I don't think they are going to go to conservative universities and try to take their money away or take money, sanction law firms. I think there are certain things that the values of the party will be sufficiently different that they won't do. But I absolutely do believe that the ratchet that Trump has moved in one direction, the tools he has used will be used by the other side in a more aggressive way than they have in the past. And talk about the the difference. The elites. When the Democratic administration has an executive order, it has to go through the Office of Legal Counsel at the Justice Department, has to go to the White House counsel. Screw that bullshit next time. It's like the White House is going to issue executive orders because somebody came up with an idea in the way it is now, and I don't think that's necessarily the worst idea in the world. That the procedural fixation of Democrats is something that could use some loosening up, and they could learn something from the Trump administration.
It's kind of a dark thought.
Well, I can see that, and good legal proceduralist that you are, you think it's a dark thought. I think it's great.
Maybe a tool to get through logjams, or maybe a tool to have executives get more done, whether for good or for ill.
No, more. I'm bigger radical than that. Like tools to get shit done as soon as possible. And as I mean, apparently what Trump says, literally like word for word, is, well, let's do this, and if the courts stop us, the courts stop us. But I don't think that attitude is something Democrats should reject entirely.
I want to bring it back to law firms. Does this signal some type of high point past of law firm power, of global law firm power, or big law power?
I don't know if it's about power, but I think it's about structure of law firms. One of the things, certainly when I was in law school, and I think even today, law firms are perceived as having personalities, as having values, and I think that's going to fade, and it should. I mean, I don't know whether it should or shouldn't, but Paul Weiss is the classic example of it was like the liberal firm, and Simon Rifkin and Arthur Lyman and Ted Sorensen were all there, and I mean, it never paid to be too idealistic about law firms. I mean, they were always about doing well as doing good,
making a lot of.
Yeah, but now, I mean, the difference among the law firms, I think, is just going to be only about the skills of the lawyers involved, not not that Paul Weiss is a certain kind of place and Sullivan and Cromwell is a different kind of place. I think they're all so similar now.
That strikes me as right. As law firms get bigger, it gets harder and harder to maintain a distinctive personality. I mean, it's just really hard to have an organization of 1,000 people not just be a random sample of the lawyer population writ large.
This is above my pay grade and expertise, but when has that ever stopped me before? Why are law firms? I mean, I understand that there are state regulations that have something to do with how law firms are structured. But as I understand it, Kirkland and Ellis, which I have not mentioned as in one of the capitulating firms, it certainly is, it's an $8 billion a year business.
Huge.
Why should it be a partnership? That's like crazy. It's so big. I mean, shouldn't it be just like a corporation with a president and a
Give
group
some
of vice
equity to
presidents?
those associates.
Exactly. I mean, it seems very old fashioned to me, and it contributes to the impression. I mean, no one goes to work at Walmart and thinks, Walmart corporate and thinks, oh, well, there are like 1,000 of us who are going to make decisions about the future of the firm. No, it's like a business, and there's a CEO, and he or she sets the tone, and that's. I mean, I just have to believe law firms are going to evolve in that direction. When you have a firm of 2,000 lawyers, how could it be otherwise?
Well, thank you for teeing up two of our upcoming conversations perfectly.
Yes, this is a topic we'll be exploring at length.
And I'll listen and learn.
Jeff, you and John were kind of suggesting that we'll be moving towards some type of homogenization of law firms, maybe some of the special sauce or culture may start to bleed from one into another. I'm curious whether you see the possibility of the opposite, or at least in a political sense. Maybe a law firm becoming much more conservative, or a law firm becoming much more liberal, either in general or changing with the administrations.
Well, I do think that you are seeing thriving boutique law firms that have distinctive political personalities. I was very interested to see that Harvard, in its fight against the administration, retained a smallish Washington law firm that is staffed almost entirely by Ted Cruz alums and lawyers who come out of the conservative movement who will be representing Harvard. And I think that was a very savvy decision on Harvard's part.
Bill Burke at Quinn Emanuel used to represent the Trump administration. He's been
Right. Although he is, he is now somewhat estranged from the Trump administration, in part because of his involvement in these cases. So I think in the small law firm world, you are going to see more or less politically aligned law firms. When you get to the big firms, I think the trend is going to be in the opposite direction.
Stay in your lane, kind of a thing.
Stay out of politics. I mean, Skadden has, I think, 2,000 lawyers. I don't think Skadden wants to have a political profile. Individual lawyers will give money to this candidate or that candidate. But I think, and I don't say this with a lot of confidence. Maybe this is wrong. I mean, you look at Sullivan and Cromwell. Sullivan and Cromwell decided to. I mean, so much has happened since then. If people forget this, Sullivan and Cromwell represents Donald Trump in his appeal of his conviction in the Manhattan criminal case. That was very controversial, and a lot of people at that law firm were not happy about it.
And were they spared from these executive orders?
Yes.
Bob Jifra helped to negotiate the Paul Weiss settlement.
Absolutely. Absolutely.
Right.
I don't know if that's a counterexample to what I'm suggesting about the relatively apolitical nature of big law firms. But, these firms, I think they recognize that they are going to be in business, or they hope to be in business across many administrations that may be of different parties. And I think their goal politically will be more to keep their heads down than to identify with one party or the other.
I can't resist just offering a quick analogy here. Big banks generate a lot of legal business, but they don't like to be sued. And so every big law firm has a choice to make. Are we going to represent big banks or are we going to sue them? And most of them choose to represent the big banks and not to sue them. We're going to talk with John Quinn later, who's been willing to sue them. But I think what we'll see is a similar bifurcation of the industry where you either antagonize the government or you do general business, but you don't do both.
And I wonder what you think about this in terms of bifurcation. Will you see a bifurcation between corporate law firms and litigating law firms? Because that, in the fight, internal fights at these places like Paul Weiss, that split exists. Do you think that might happen?
I think it might happen. To put a point a little bit more narrowly, I think it'll be corporate law firms and litigating law firms that litigate in ways that antagonize the government. Corporate lawyers can be paired with litigators who just do contract disputes, but not litigators who represent, who seek injunctions against the government.
Jeffrey Toobin, it's been a fantastic conversation. I mean, I can tell you do this for a living.
Yes, I do. But not for so long. What an interesting, lengthy conversation. I usually have to get on and off CNN in like 3 minutes. So this is great.
And we didn't even send hair and makeup.
That's right. Yeah, as you can tell. God. But no, I really enjoyed it. I thank you for asking me, and good luck in your podcast.